Conclusion: Justice K.S. Puttaswamy, Retd, and Anarv Union of India and Ors, is a watershed in Indian constitutional jurisprudence, firmly establishing the right to privacy as a cornerstone of human dignity and freedom. The case sets a significant precedent for how privacy concerns are to be balanced with state interest in the context of modern technologies and governance strategies. Abstract. This case summary primarily examines about the fundamental essence of the right to privacy and its ancillary legal repercussions. Justice K.S. Puttaswamy is a retired judge of the Karnataka High Court who was also the original petitioner, challenging the government of India over making Aadhaar mandatory. He had filed a writ petition in 2012, and over the last 5 years, 26 other petitions have been tagged along with his. Challenging the scheme, retired Justice K.S. Puttaswamy turned litigant for the first time in his legal career, spanning 5 decades, when he petitioned the Supreme Court against the linking of state benefits to the UID scheme, saying that much money has been wasted on the dangerous project, arguing passionately that it is a clear violation of citizens' privacy, and among various other reasons, this program was rejected by the Parliamentary Standing Committee on Finance, but still the government of India went ahead with it. How can this awfully wrong program roll out without a clear legislation? Justice K.S. Puttaswamy filed the PIL for scrapping the Aadhaar project in 2012. On 24 August 2017, a 9-judge bench of the Supreme Court of India, in a remarkable and wide-ranging 547-page judgment, ruled unanimously that privacy is a constitutionally protected right in India, in the case of Puttaswamy v. Union of India. With the Supreme Court declaring the right to privacy a fundamental right, Justice K.S. Puttaswamy said, "I'm completely vindicated by the decision. My contention had always been that Aadhaar enrollment can be made voluntary, in which case I would not have petitioned." In February 2020, the High Court of Kenya at Nairobi referred to the Indian Supreme Court judgment in Justice K.S. Puttaswamy, Retd, and another v. Union of India and others, to hold that biometric data is necessary for identification purposes, and adopted the findings in Justice K.S. Puttaswamy, Retd, on the necessity of different types of biometric data in identification. Facts of Justice K.S. Puttaswamy, Retd, Union of India. The case was brought by 91-year-old retired High Court Judge Puttaswamy against the Union of India, the Government of India, up on reference from the Constitution bench, to determine whether the right to privacy was guaranteed as an independent fundamental right, following conflicting decisions from other Supreme Court benches. The latest case had concerned a challenge to the government's Aadhaar scheme, a form of uniform biometrics-based identity card, which the government proposed making mandatory for access to government services and benefits. The challenge was made before a 3-judge bench of the Supreme Court on the basis that the scheme violated the right to privacy. However, the Attorney General argued on behalf of the Union of India that the Indian Constitution does not grant specific protection for the right to privacy. He based this on observations made in the case of MP Sharma de Vrir, Satish Chandra, an 8-judge bench, and Karak Singh v. Uttar Pradesh, a 5-judge bench. However, a subsequent 11-judge bench found that fundamental rights were not to be construed as distinct unrelated rights, thereby upholding the dissenting view in Karak Singh. This also formed the basis of later decisions by smaller benches of the Supreme Court, which expressly recognized the right to privacy. It was in this context that a Constitution bench was set up and concluded that there was a need for a 9-judge bench to determine whether there was a fundamental right to privacy within the Constitution. The petitioner argued before the 9-judge bench that this right was an independent right, guaranteed by the right to life with dignity, under Article 21 of the Constitution. The respondent submitted that the Constitution only recognized personal liberties, which may incorporate the right to privacy to a limited extent. The court considered detailed arguments on the nature of fundamental rights, constitutional interpretation, and the theoretical and philosophical basis for the right to privacy, as well as the nature of this right, issues raised in Justice K.S. Puttaswamy, Retd, Union of India. Whether the Aadhaar project creates or has tendency to create surveillance state and is thus unconstitutional on this ground. What is the magnitude of protection that needs to be accorded to collection, storage,